Welcome to our program. My name is Glenn Lammi. I am Chief Counsel and Executive Director of Washington Legal Foundation. We're very pleased to have you with us here today. Thanks so much for joining us. For those of you not familiar with the foundation, we are in our 47th year of public interest law, policy, advocacy, and education. We engage in that through a number of different means, filing briefs in the Supreme Court and in the lower federal courts and state courts, as well as publishing papers in various lengths and curating a website called the WLF Legal Pulse. We also do programs such as this one, and we're really pleased to have you here today. The decision in the companion Loper, Bright, and Relentless cases and an SEC bar versus Jarkesy have, as our program's title reflects, created opportunities and risks for regulated entities. HHS and its 13 operating divisions touch a huge percentage of the U.S. economy, and many of those divisions' most important decisions are based on interpretations of broadly drafted statutes. That's where the Loper, Bright, and Relentless cases come in. And that's especially true for the enforcement actions from FDA, CMS, OIG, and those and other HHS entities also issue plenty of civil monetary penalties where the questions raised in the Jarkesy case come in. We're pleased to have with us today two attorneys from a firm that's always at the cutting edge of healthcare legal activity. I'll announce them briefly, and then we'll get into the discussion. Brenna Jenny is a partner in the Washington, D.C. office of Sidley Austin. She represents clients in the healthcare industry and government enforcement actions, internal investigations, and compliance reviews. Brenna previously served as the principal deputy general counsel at HHS and the chief legal officer at the Centers for Medicare and Medicaid Services. Prior to joining HHS, Brenna served as counsel to the Assistant Attorney General of the Civil Division of the Department of Justice. Sean Griffin is also a partner in the Washington, D.C. office of Sidley Austin. He represents life sciences clients in disputes with state and federal agencies and in government enforcement matters. He routinely represents clients before CMS and FDA, as well as in the courts around the country. Just wanted to remind you that we are recording today. If you have any questions, please use the Q&A function located in the Zoom webinar toolbar to ask any questions. We'll also be using a PowerPoint presentation, and the slides, if you'd like to download them, are in the chat. So I will hand it over to our participants.
So thanks, Glenn.
Sorry, wrong one. Sorry about that. This happens when you have too many windows open. What is going on here? Sorry. All right. There we go. Okay, I think we're set now.
Okay, well, let's go to the agenda slide. And thank you, everyone, for joining us this afternoon. We're going to cover two of the big cases from the last term of the Supreme Court. The Loper Bright decision, which has gotten a lot of press and may have, depending upon who you ask, upended the way we do statutory interpretation in the federal courts. I'm going to cover that, and I'm also going to talk about some specific implications it may have for FDA, sort of beyond the general big picture takeaway. We're also going to talk about SEC v. Jarkesy, which has more to do with how agencies bring enforcement actions. It has, Brenna's going to cover that because, frankly, ALJ practice and civil money penalties practice is not a huge part of FDA's docket and is much more active in other parts of HHS. So if we can continue. Next slide, please. All right. So for those who have been following along, Chevron deference has been the law of the land or was the law of the land for roughly 40 years, and has been controversial for at least half that time. And finally, in the last term, two different cases came up to the Supreme Court about a statutory interpretation problem involving the National Marine Fisheries Service. The specific question was whether or not the vessels were required to pay the cost of onboard third-party monitors who would accompany the fishing ships out to make sure that they observed the rules for designed to prevent overfishing. The Supreme Court wanted nothing to do with that question or the merits of third-party monitor question, and the question presented was solely whether this court should overrule or clarify the Chevron doctrine. And you know that that's what they mean, because when you read Loper Bright, which was the resulting opinion because it was the lower number case, there's only about a page of discussion of the actual controversy. It ends with the point that both the DC Circuit and the First Circuit resolved the case based on Chevron deference, which was the cause for the question that was presented. Next slide. All right. The Chevron doctrine was a two-step process. Originally, it got expanded over time a bit. But in general, the question is whether or not there's a clear answer to the statutory question. So if Congress has directly spoken to the precise question at issue, then the court will just resolve that question and to tell everyone what the plain text of the statute means. However, if the statute is found to be silent or ambiguous, the court moves on to Chevron step 2, and at Chevron step 2, this is where the deference idea comes from, the court will accept any reasonable position. And this was originally promulgated as an approach to statutory interpretation in the 1980s to create flexibility for agencies. The thinking was at the time that we didn't want agency policy, even when the agency policy was based on interpretation of the statute in question. We didn't want it to be rigid, and we didn't want it to be locked in time. We wanted the political process to have consequences and to allow agencies to revisit and even reverse their prior policies and move in different directions. Next slide, please. Fast forward to today, Chevron had gotten very complicated in practice. There was something called Chevron Step 0, which asked whether or not the agency's position was adequately and properly documented in something with the formality necessary to warrant judicial deference. And finally, Loper Bright decided that we were not going to do this anymore. And the justification was primarily the text of the Administrative Procedure Act, which governs a lot of cases brought against federal agencies directly, and also provides a standard of review in a whole nother body of cases where the judicial review statute will cross-reference the APA. So it's very broadly applicable, although not universally so. And in the APA's review provision, it specifically says that the court shall decide all relevant questions of law and interpret statutory provisions. And the court essentially said, the majority essentially said, look, that's your job. You have to finish it, even if you think the statute's ambiguous. You, the court, have to pick which one is correct. And you can't just stop and say the agency wins because it's close enough. And there's a lot in the opinion about sort of the historical development of the APA and judicial review even prior to the APA, how courts acted under the APA for the first 3 or 4 decades before Chevron happened. And there's a lot of policy about, is it better to have judges do this or agencies do this? But at the end of the day, the court said, look, the APA says what it says. We think this is what the role of the judiciary should be, going all the way back to Marbury v. Madison. And we think that, frankly, we, the judiciary, are better suited to resolving statutory questions because agencies have no special competence in that. They may have technical expertise. They may understand, for instance, the FCC may understand how internet networks work better than the courts do, but they don't understand the statute or what Congress does or all the tools of statutory interpretation better than we do. Next slide. So even now, though, and this is one of the places where some of the press coverage of Loper Bright has been a bit hyperbolic when they say that the courts are going to start ignoring agencies altogether. That's not exactly right. Part of what the majority did was to try to turn back the clock a bit to how things were done at the time of the APA, where Skidmore deference was sort of the norm. And this is the idea that, the courts should listen to the executive. It's a question of comedy between the branches of government, and the executive's experience is entitled to weight to the extent it has the power to persuade. And the real difference is that, the courts are going to look at that and build it into their analysis, but answer the question as to what the law says, not take what the executive says and says, that's what we'll go with, right? So where Chevron was controlling at step 2, Skidmore remains available throughout the exercise of statutory interpretation if the government's position is persuasive. And one place where it will be most persuasive is where the agency's position has been clearly maintained consistently over a long period of time. Those tend to be the cases where Skidmore deference is most persuasive. Next slide. There's also a wrinkle in Loper Bright because Chevron had grown to mean multiple things. So courts would defer to agencies sometimes because they looked at a statute and they couldn't tell what a particular clause of the statute was intended to mean by Congress. They would also defer to agencies where Congress had said, you, FDA, shall issue regulations defining such and such an issue. And those two things sort of got conflated and combined into one doctrine over the years under Chevron. And part of what Loper Bright is saying is that those are actually very different things, right? When Congress has explicitly delegated rulemaking authority to an agency, it's appropriate to judge Congress's intent as we should give the agency some room here and be very deferential in reviewing what they're doing. But where the statute is just ambiguous, it's kind of difficult to think that Congress intended for the ambiguity to be resolved by the agency. And that's really what they were attacking. So the majority's opinion does preserve the rulemaking deference idea. So if the statute expressly delegates authority, is what the courts should do is fix the boundaries of delegated authority and then just ensure whether the agency is engaged in reasoned decision-making within that authority. And reasoned decision-making is an important phrase because it carries with it a whole body of APA law. And the idea is that what we're going to do is ask whether or not the agency has considered the relevant factors, weighed the relevant evidence, and told us what they're going to do in plausible and reasonable ways. And it doesn't say, we're going to look at this factual situation and determine what the best policy is, or what the best outcome or correct outcome is. So again, this is deferential and not that different than what Chevron Step 2 deference looked like in practice, and it is preserved even after Loper Bright. Next slide. All right. So with that as background, I wanted to talk about a few places where this is going to come up. Either it already has, or I'm just prognosticating and guessing where it would come up. So starting with something that's already arisen, the laboratory developed test rule. This has already been challenged. I've got a summary here of one of two cases. There's also a more recent case that was filed also in Texas by a group of pathologists and a pathologist who's resident in Texas. I'll talk about that in a second. But the idea here is that clinical laboratories, imagine going to the doctor, they take your blood, they send it off to a lab to run a cholesterol panel, and then you get the results back. The service provided by the lab in that scenario is typically referred to as a laboratory developed test. In the case I gave, a cholesterol test. FDA has long claimed, but not really exercised, authority to regulate laboratory tests under the medical device authorities added to the Federal Food, Drug, and Cosmetic Act in 1976. In 2023, they sort of finally proposed to resolve the issue. And they put out a proposed LDT rule where they said, this is what we're going to regulate now. We're going to assert and resolve our authority. They finalized that rule earlier this year, and it made a single change to a regulation, which basically just said that in vitro diagnostic products are devices, and they added the phrase, including when the manufacturer of these products is a laboratory. This has been a long time coming. This issue first came up in litigation in the early 90s. It was not resolved by the courts. The 10th Circuit had the opportunity to address it and just ducked. And ever since then, people in the bar and the agency and some companies have been fighting about this. And so it was not at all surprising that in the wake of the final rule, a lawsuit was filed. It was filed by a trade association, the American Clinical Laboratories Association. But as is the case with all association groups or lawsuits, that you have to have participation from individual members to establish standing. And so here we know that the entities that are bringing the suit are LabCorp and Quest, two of the biggest, the Mayo Clinic, very important healthcare provider, and two smaller companies called HealthTrack and ARUP Labs. HealthTrack is based in Texas, which gave ACLA, who's based in DC, the venue that they preferred. A lot of the issues that are presented in this fight are very old, but some of them are new. So one, this case, I think, presents FDA's first run-in with the major questions doctrine, which the Supreme Court gave new force a few terms ago in West Virginia v. APA. There's also been a long-running fight about whether there's concurrent jurisdiction between the FDCA and CLIA. For those who follow FDA law, you know that FDA has lost a number of important concurrent jurisdiction cases. Brown and Williamson about tobacco in 2000 in the Supreme Court, but also things like poison preventing packaging with the CPSC, alcohol other things where other agencies have been found by the courts to be the proper regulator, and FDA was seen as an interloper trying to stretch the FTC beyond its text and its usually understood jurisdiction. But also in this case is a simple statutory question: are testing services devices? Next slide. All right, so what we're talking about here, per the complaint, is a series of processes and tasks undertaken by trained professionals using instruments and tools to derive information. The complaint identifies blood samples as well as genomic testing. You turn to the statute. The first clause of the device definition, known as the instrument clause, says that a device is an instrument, apparatus, implement, machine, contrivance, implant, in vitro reagent, or similar or other related article, including any component part or accessory. So the question then becomes whether a series of processes and tasks fits within any of those nouns running from instrument to article. And the argument that ACLA and AMP are making in their cases is that no, those nouns all mean physical things. We're looking at widgets that actually move through commerce, and not services that are contracted out and provided for a fee. And this is fundamentally where Loper Bright comes in. Because in the past, and including the Genus Medical Tech case cited on the slide, the courts have expressly said, when it's a close call whether or not something falls within the instrument clause, we're probably going to defer to the agency under Chevron. Now they can't do that. So at least at that level, one of the ways FDA could have won this fight is gone, and the plaintiff's position becomes that much stronger. Next slide. Another example that comes up a lot pertains to the approval standards for therapeutic products like drugs and devices. Both statutory standards basically require evidence of effectiveness. It's reasonable assurance under the device standard and substantial evidence under the drug standard. And we understand through decades of practice that means you need an adequate and well-controlled clinical trial, at least one, that showed a statistically significant treatment effect that was of sufficient magnitude and on an important enough measure to be clinically significant in a disease state that's real. And the question becomes, how much of that is actually in the statute, right? So the text of the NDA statute is substantial evidence that the drug will have the effect it purports or is represented to have. Does that really mean it has to reach a certain level of magnitude? It just says the effect it purports to have. And does it really mean that the effect has to be clinically significant? These are questions that FDA won in court a long time ago, and they won under Chevron. And so the question, should this come up again, say, following a denial of an NDA or a BLA, should it come up again, litigants may try to re-raise these issues and relitigate them. And the Supreme Court said that precedent is still precedent in Loper Bright, and we don't mean to just toss away everything that was decided under Chevron. But particularly if you, say, go to a circuit where there isn't a binding precedent, you can find room to relitigate things. And so this creates a lot of uncertainty for FDA. And importantly, if you're working with a company that is developing a therapeutic product, it makes it a lot more plausible to push back on FDA statements that we don't find this data set compelling enough to support approval, which was prior to Loper Bright thought to be a place where arguing with FDA is mostly hopeless. These sorts of statutory issues might turn that around a bit and make those conversations a little bit easier to have. Next slide. Shifting to the enforcement venue, one of, and this is a place where there's actually a fair bit of WLF writing and even case law created by WLF. One of the areas where FDA enforcement is most important is related to off-label promotion. And for drugs, at least, the restriction on off-label promotion comes from a provision of the FDCA, Section 502F1, that says the labeling for every drug has to bear adequate directions for use, except that means lay use, while Section 503B1 says prescription drugs are by definition not safe for use except under the supervision of a provider, which would mean if you just added those two things up syllogistically, that all prescription drugs are necessarily misbranded, which is an impossible result. So how do we get out of that box? Industry has long contended that Section 503 solved the same problem that it created. So in the next breath, it says that a prescription drug that's dispensed on a prescription is exempt from 502, except for certain paragraphs. And notably, 502F is not listed, so it is exempt. A prescription drug should be exempt from 502F1, meaning there is no statutory contradiction. FDA has a very, very different take. FDA says that the 503 thing that I just pointed to only applies at the point of dispensing. At all times prior to dispensing, the drug is subject to all of 502, including 502F1. And that Congress did create a contradiction, but it relied on FDA to solve it through FDA's rulemaking authority, where 502F says that FDA may exempt a drug from 502F. FDA then takes that exemption authority and says that includes the authority to impose conditions on the exemption. And so we'll exempt prescription drugs from the adequate directions requirement on the condition that the drug's labeling contains adequate information for all of the drug's intended uses. Intended use can be determined per FDA based on any relevant evidence. And here we are. We can regulate a drug as misbranded just because a sales rep made oral statements to a doctor, even though that has nothing to do with the labeling, and we can move forward. And this feels like exactly the kind of theory that is subject to renewed scrutiny after Loper. You're not going, it's just, if you take the usual canons of statutory interpretation and you apply it to this, it's much easier to that Congress avoided a contradiction by including an exception in 503 than it is to think that Congress intentionally created a contradiction, one that would make every prescription drug misbranded and contraband under federal law, and then said, FDA, please solve this problem for us. So that's one thing that I think is going to be very important for industry in the coming years. Next slide. Brenna, do you want to take over here and talk about some Loper problems for CMS?
Yeah, so I can cover CMS and some of the other areas of HHS. So first one, as Sean noted, one area where the Loper-Bright court expressly preserved some discretion for federal agencies is where they are delegated the task of filling in gaps. They're still going to get some deference there. And so this happens a fair amount when it comes to Medicare and Medicaid, because Congress simply can't engage in the detailed level of policymaking that's necessary to actually operate federal healthcare programs. It has to punt to a certain level to CMS. So perhaps one of the most well-known delegations that I think CMS would point to is the mandate in the Medicare Act that Medicare cover only items and services that are reasonable and necessary for the diagnosis or treatment of illness or injury. And I think CMS probably has a reasonably good argument that when they engage in rulemaking that defines what is reasonable and necessary in the context of specific treatments, modalities, et cetera, they're filling a gap that Congress delegated them to fill, and so they're going to get some deference. But the Loper Bright court did put some constraints around that deference and explained that courts still need to police the outer bounds of a delegation. In other words, you can't defer to an agency's assertion that it is gap filling and therefore gets deference. That question of whether an agency is in the first instance actually executing a delegation is not a question they get deference to. You have to clear that hurdle, and then you can look at the substance and say, okay, are what they are doing in this gap filling circumstances, is that a reasonable read of the statute? Which I think is an important protection for regulated entities. And courts, though, also are going to be making sure that when agencies exercise their discretion, it has to be in a manner that's consistent with the APA. So they can't issue rules that contradict other laws or are arbitrary and capricious. So one question I thought of that may arise is, can CMS, when it's exercising the delegated task of figuring out what's reasonable and necessary, can they contradict FDA decisions on safety and efficacy? So in other words, if FDA concludes that a drug or device is safe and effective, which involves a task that arguably is FDA exercising its own delegation from Congress, can CMS then turn around and decide that that drug or device is nonetheless not reasonable and necessary? If there's room post-Loper Bright, I think it's going to be a narrow needle to thread, but I think that I could see some tension there coming up post-Loper Bright. Next slide. Another area where I think Loper Bright raises some interesting questions is the anti-kickback statute, or AKS, which is enforced by the HHS Office of Inspector General. As some of you probably know, the AKS is a really broad, essentially bilateral anti-bribery rule. So it prohibits giving or receiving anything of value to induce referrals or recommendations of your products where they're reimbursable by federal healthcare programs. The law is actually so broad that on its face, it would technically prohibit companies from even paying their own employees to go out and recommend their products. Obviously, that's not workable. And so the AKS does have certain statutory exceptions built into it that exclude from what would otherwise be covered by the AKS certain types of payments and arrangements, including, for example, payments to employees. Also covers things like discounts. And the full text of the discount statutory exception is on the left hand of the slide. Relatively straight and straightforward. HHS OIG also has the authority to issue safe harbors through regulations, through a rulemaking process. And if an arrangement satisfies every single element of a safe harbor, then it's also considered not to be a violation of the AKS. There are a lot more safe harbors and statutory exceptions because it's obviously a lot easier for HHS OIG to issue new rules than it is for Congress to add statutory exceptions. So they're not parallel, but there is some overlap. So for example, HHS OIG chose to make some of its own versions of some of the statutory exceptions, including discounts. So the full text of the discount safe harbor would actually span a couple of slides. It's very long, much longer than the statutory text. There are very specific rules for buyers and sellers, and those rules also vary based on whether the provider is, or the buyer is a provider that submits cost reports, such as a hospital versus not. So very specific rules, specific carve-outs. And I think post-Loper Bright, there are questions. How can you kind of pretend that what is on the right here, this discount, a safe harbor, that is just a matter of statutory interpretation, that this is the one best meaning of the rule? For example, what is the single best meaning of properly disclosed? You see that on the statutory language. A discount has to be properly disclosed. What does that mean? There's a lot of specific boxes to check under the regulatory safe harbor. And I think if you were to say what's the best statutory interpretation of properly disclosed, it would probably be a functional, flexible definition that would focus on an outcome of transparency rather than just requiring specific boxes to be checked. But that's not the regime that we operate under on the safe harbor side. And nonetheless, HHS OIG has long taken the position that the discount safe harbor and the discount statutory exception are coterminous. The defense bar has long taken the position that they are not, because they're obviously not. But OIG's position has kind of trumped because they enforce the AKS. And so industry has generally tried to conform its conduct to the scope of the safe harbor. And so the statutory exception has, I think, in practice become kind of a dead letter. But I think Loper Bright is going to create vulnerabilities for OIG's discount safe harbor approach, because OIG is clearly imposing different and additional requirements than the statutory exception, and they can't contradict the statute. So I do think we're going to start to see challenges to this regime, likely in the context of healthcare companies facing False Claims Act enforcement actions that are premised on alleged violations of the anti-kickback statute and questions over whether discount arrangements are protected or not. Next slide. One last example that might be of interest to this crowd. I'm sure many of you have seen some politicians making waves, encouraging the government to exercise march-in rights as a way to combat drug prices that are supposedly too high. The underlying legal theory, though, is a bit of a stretch, and I think it's going to become more of an uphill battle post-Loper Bright. So the relevant statute, which is the Patent and Trademark Act amendments of 1980, give government contractors the authority to retain patent rights for inventions made with federal funding in certain specified circumstances. And one of those circumstances is at the bottom left. It's that the patent holder has failed to take effective steps to achieve practical application of the invention. And practical application is further defined in the statute as available to the public on reasonable terms. And so someone came up with a creative theory that if a drug price is deemed too high, the manufacturer has failed to take effective steps to achieve practical application because the drug isn't available to the public on reasonable terms. I think if the question is whether this theory is a permissible read of the statute, it might be a closer call. But if someone has to argue that the single best reading of this provision is that judges are allowed to second-guess prices set by patent holders and try and make assessments about whether that price is too high and use this provision as a means to set price ceilings or other price controls, I think that's going to be a stretch post-Loper Bright. And Senator Bill Cassidy recently sent a letter to HHS in the wake of Loper Bright, raising a number of questions kind of coming out of the decision. And you can see here on the slide, one of the questions that he did raise involves this theory of, is HHS still going to try and justify the NIH invoking march-in rights for drug patents post-Loper Bright? Certainly not something HHS will answer in this context, but I think something that could well be litigated in the future. Next slide. So we're going to pivot to talk about another case, SEC versus Jarkesy. If you want to go to the next slide. This case came out actually right before Loper Bright, and it also creates some new opportunities and some new open questions in the admin law world. So the SEC alleged that Mr. Jarkesy, an investment fund manager, had defrauded his customers in violation of federal securities laws. And so the SEC initiated an enforcement action against Jarkesy seeking $300,000 in civil monetary penalties, which I'll refer to as CMPs. And by statute, the SEC had two potential venues they could pursue. They could go to federal court and have an Article III judge preside over the hearings and have a jury of Jarkesy's peers decide the facts. Or they could use the SEC's in-house tribunal, which would involve an administrative law judge, often referred to as an ALJ, who would act as both judge and jury. In Jarkesy's case, the SEC chose the latter. The ALJ found Jarkesy liable, and then after a 6-year delay, the SEC affirmed the ALJ's order. Jarkesy ended up then finally being able to get out and have judicial review, worked its way up to the Fifth Circuit, which held that the SEC's decision to require Mr. Jarkesy to go through an in-house administrative proceeding and impose CMPs through that process violated Mr. Jarkesy's Seventh Amendment right to a jury trial. Going all the way up to the Supreme Court, the court affirmed. And on the one hand, the holding itself is relatively narrow. The holding is that the Seventh Amendment entitles a defendant to a jury trial when the SEC seeks civil penalties for securities fraud. But the logic of this decision has much broader implications for healthcare enforcement. Next slide. So the majority set forth a two-step framework of analysis that I think broadly applies to HHS agency actions as well. So the first question is, does the action implicate the Seventh Amendment? And then second, even if it does the public rights exception apply? And the public rights exception is something that the Supreme Court recognized a number of years ago. And the notion is that Congress can create new statutory rights that are considered public rights. And so kind of a core example of this is claims for benefits against the government. And the idea is that where Congress does create a new statutory right that's a public right, it can channel that through an administrative-only process. So on the first question, the court explained that the Seventh Amendment covers all suits which are not of equity or admiralty jurisdiction. In other words, claims that are legal in nature. So the first question is the action legal in nature as opposed to equitable? And the court here reiterated that whether a claim is statutory or not is immaterial to this analysis. The cause of action might be relevant, but whether or not it derives from a statute is not dispositive. Rather, you have to look at the remedy. And the court said here, the remedy is a civil monetary penalty that is designed, at least in part, to punish or deter, as opposed to being solely remedial. And the court said with that kind of remedy, that is a legal action in nature, and so the Seventh Amendment applies. On the next question, whether the public rights exception would nonetheless kind of claw this out of the purview of the Seventh Amendment, the majority and dissenters really sparred over the breadth of the public rights exception. The majority explained, though, that if a suit is the nature of an action at common law, such as here, a fraud-based action, then that matter presumptively concerns private rights. And so you have to be in an Article III court, then you have a right to a jury. So the majority found that was met here with this fraud-based action, and so they said public rights exception cannot apply. The dissenters had taken the government's position, and they said, at a minimum, the public rights exception allows Congress to create new statutory obligations, impose CMPs for their violation, and then move that all through an administrative agency to decide whether a violation occurred. So in their view, because Congress had created these penalties for violations of SEC rules, Congress could choose to channel that solely through an administrative process. The majority disagreed. They said that can't possibly be right because that would drive a truck through the Seventh Amendment. You could just get Congress to mirror any sort of common law right, create a specific statutory right for it, and then allow everything to be channeled through an administrative process. They said it would completely gut the protections, which I think is right. And they further pointed out there's no textual basis in the Constitution for the public rights exception. It's really kind of a judicially created exception. And so I think the court reiterated that it has to be read very narrowly. And the court also reiterated that agencies, if they're trying to make arguments about whether or not something can be forcibly channeled into an administrative proceeding, you can't point to factors like increasing efficiency or reducing public costs. That's not enough to trigger the public rights exception. You really have to look at the nature of the dispute. So at base, I think the lesson coming out of Jarkesy is that if you have civil monetary penalties that are designed to punish or deter, as opposed to being remedial, such as repaying overpayments, that would be an example of a remedial monetary penalty, then defendants get to be in court, and it doesn't matter if the penalty is derived from a new statutory scheme. Next slide. And I think the recognition that defendants can be in court for these types of civil monetary proceedings is really powerful because the forum really matters for defendants. And this is an excerpt from the majority's opinion, but they were comparing and contrasting the procedural rights that defendants have in federal court versus an SEC ALJ proceeding. And they highlighted that defendants have far fewer procedural protections in administrative proceedings, which of course is exactly why the founders guaranteed the right to a court and to a jury for certain types of adversarial proceedings. So I'm a healthcare lawyer. I haven't litigated, obviously, in an SEC ALJ proceeding. But I can say that I was before a DEA ALJ on behalf of a pharmacy that allegedly violated the Controlled Substances Act. And I can tell you it is a total kangaroo court. We were adverse before DEA line attorneys in front of a DEA appointed ALJ. And the ALJ's job was to make a recommendation that went up to, guess who? The DEA administrator, who could then agree or disagree or modify the recommendation. But it was basically this kind of sham proceeding where you were pretending to be adverse to the very people who then got to decide anyway what the outcome would be. And we had no right to subpoena documents from DEA. They could ask us to produce anything. We didn't get to demand that they produce any documents, even though we had evidence that they had exculpatory documents that they weren't willing to search for. So it's really, really highlighted for me how important it is to get into federal court if you have the opportunity to do that. Next slide. So I think it's guaranteed that HHS is grappling with Jarkesy right now, and it's probably taking up more bandwidth for them, I bet, than Loper Bright, because HHS has a range of civil monetary penalty authorities. Every year they update the CMP amounts to account for inflation. This is an image from the most recent update, but it actually, all of the pages listing all of the CMP authorities and all of the amounts spans more than 22 pages in the Federal Register. So they have a lot of authorities that they can invoke. And I think especially on the CMS side and the OIG side, Office of Civil Rights, which enforces HIPAA, they use these CMP authorities. Now, a lot of them do apply more to providers, but for the life sciences company folks on the phone, HHS OIG does have CMP authority that is applicable to you, including failure to return overpayments, violations of the anti-kickback statute, and failing to provide accurate information about Medicaid drug rebates. So I think HHS has a lot of questions to think about how they're going to deal with Jarkesy and their CMP authorities moving forward, because right now they go through an administrative process just like the SEC. Next slide. And I think the first question HHS is going to be grappling with is whether they affirmatively concede that with respect to at least some subset of their CMP authorities, defendants have a right to be in court. I think the Supreme Court made very clear that CMPs imposed for violations of law that are akin to common law fraud are clearly protected by the 7th Amendment. And HHS OIG in particular has a number of CMP authorities that cover misconduct specific to the healthcare sector, but that are very close to common law fraud. And I think it's going to be very difficult for HHS OIG to maintain that Jarkesy changes nothing on that front. So it's possible we could see HHS preemptively acknowledge that some of those CMP authorities, the ones that are really close to common law fraud, are now covered by a right to be in court. But I also think that HHS certainly isn't going to concede that all of their CMP authorities are affected by Jarkesy. I think they're going to argue that where HHS is imposing CMPs pursuant to a newer statutory regime, so for example, penalties for violating HIPAA or EMTALA, HHS is going to say that is unaffected by Jarkesy. I would argue they're clearly wrong. They're taking the minorities side, which was clearly didn't have enough votes to get to 5. And the majority reiterated that the 7th Amendment does apply to novel statutory regimes. That's a quote. So long as the claims are akin to common law claims. And I think under the rationale, CMPs that are designed to punish are akin to common law claims. So I expect this is going to be worked out in litigation, but that we'll see defendants in CMP administrative actions suing to get into federal court. One way, as another open question, I think there's a question of whether HHS is going to turn more to equitable remedies, because that's one way HHS might be able to sidestep some of Jarkesy's implications, because the 7th Amendment does focus and extend to actions that are legal in nature as opposed to equitable. So, for example, determining whether a company is eligible or ineligible to sell items or services to Medicare, i.e. your Medicare enrollment, that's going to be an equitable remedy. But obviously the financial implications from that are even more deadly than, really any conceivable CMP. So we may see HHS essentially threatening those types of extreme equitable remedies to force companies to settle out of court. After all, people can waive their Seventh Amendment rights. So it is something that people could choose to settle in an administrative proceeding rather than going to court. And it may be that they're better off doing that depending on what the agency is demanding. Finally, a question that may be of interest to folks on the line from drug companies. I think Jarkesy does call into question the 340B arbitration process. So at a very high level, the 340B statute sets out an arbitration process that purportedly is mandatory. And a covered entity provider can haul a drug company into an HHS administered arbitration process to adjudicate disputes over whether the drug company provided all of the rebates that it was obligated to provide to the covered entity. I think those types of disputes involve legal remedies, and they clearly involve private rights between companies. So I think HHS is going to be hard-pressed to argue that companies have to participate in the 340B arbitration process if they don't want to, because I think Jarkesy makes clear they have a right to be in court. And some drug companies may well prefer to be in court for those types of disputes. So that's all of the prepared content we have. We'd love to answer any questions if anyone wants to put something in the chat or go off mute.
Thank you both for your presentations. I want to ask you real quick before we get into your questions, Brenna, how would, you sort of alluded to it, but how would someone challenge the constitutionality of a civil monetary penalty? It would need to be imposed upon them first, and then they would file suit, and where would they be able to do that?
Yeah, they're good questions, and I think a lot of that is going to be sorted out, but I don't think you would need to wait until it was imposed. I mean, usually there's some sort of demand, and I think you could move to have that adjudicated in court rather than have that initial demand adjudicated through the administrative proceeding. And I think the venue rules would be the same as they would otherwise be if you were filing an APA action. So generally, you'd have to be either where the defendant is located, so DC, or if you're suing CMS, you could also get into Baltimore, or where you as the plaintiff have your principal place of business.
I was pleased that you talked about the off-label issues, Sean, and thank you for the call out to WLF. We definitely appreciate that. Have APA questions ever arisen in challenges to the FDA's off-label policy? I know our suit didn't rely on the APA, but there have been other challenges to FDA's off-label approach. Has the APA ever figured into it before, or were those also just First Amendment claims?
I think that you're referring to cases like Allergan, Par, and Amarin, right. Sort of the greatest hits of the off-label fights from what feels like a generation ago now. The simple answers, they were both. When you file a lawsuit like that, you tend to plead alternative causes of action directly under directly under the constitutional provision, two under the APA, and for boots and suspenders, some people also plead what's called ultra vires review, which is where there's no other basis for judicial review and you're just throwing a Hail Mary. One of the things that's very interesting about Loper Bright, and I think gets overlooked in most of the press coverage, is that they were cases, they weren't APA cases per se, but they were cases that were explicitly covered by the APA's judicial review provision by cross-reference. And so there, you can imagine lots of different kinds of cases that don't have that, right? So a direct case under the Constitution might not, isn't subject to the APA, and so the textual basis for Loper Bright wouldn't really be applicable. Any enforcement action is the same way, right? Any enforcement action, the government would be the plaintiff or bring a criminal case, And in that case, the government's cause of action is laid out in a statute somewhere. Those causes of action might be, say, the cause of action to bring a seizure under 21 U.S.C. 334. That provision has nothing to do with the APA. There's certainly no cross-reference there. So when a defendant raises a statutory objection as a defense in a case like that, does Loper Bright apply? We don't know.
One other thing that there has been some discussion about, I've read, is good manufacturing practices that FDA provides. Are those potentially more vulnerable to challenge now that Chevron was overruled?
Maybe is the best I can give you there. So that would fall under a similar express delegation of rulemaking authority rubric, right? At least arguably. If you know the history of the CGMP rules, you would know that in the 70s, FDA said, look, the 1962 amendments added the phrase current good manufacturing practices to the statute. And we have general rulemaking authority for the efficient enforcement of the act. And that's an enforcement provision. So we have authority to define that term. And here are 300 regulations to define that term. So in that case, the Loper Bright would say that the court's role is to set the bounds of Congress's delegation and make sure that FDA has acted reasonably within the scope of that. But that's eliding over maybe a lower or logically prior question, which would be to look at a specific CGMP rule, look at what it requires, and say that's inconsistent with some other provision of the statute. Those arguments can be tough to come by, right? Like a lot of the CGMP rules, frankly, are themselves not that controversial, and what gets controversial is sub-regulatory guidance or the application of a particular rule, and those are going to raise different kinds of APA arguments that really aren't statutory in nature. So that's a long-winded way of explaining a maybe.
So the likelihood of challenges being successful in those sub-regulatory or guidance situations, do you see those as being less? There's been a lot of litigation over the years, obviously, as to the nature of guidance documents and other things, and whether they represent final agency action. FDA and other agencies put right on them that this isn't legally binding on the parties, but certainly the guidance is expected to be followed. So certainly welcome both of your inputs on that.
Yeah, I mean, so on the one hand, Loper Bright doesn't change any of the APA rules, right? The APA rules are what require notice and comment. They establish the difference between an interpretive rule and a substantive one. None of that has changed, at least not since Perez a few terms ago. What remains, though, is if you can argue that the way FDA has applied a CGMP requirement or the terms of a guidance are inconsistent with the FDCA, then you might have a Loper Bright argument on your hands, right? If you can craft that kind of defensive argument, there could be something there. But if your point is that, look, FDA, I have an alternative way of doing this, and you're trying to impose guidance as if it's a substantive and binding norm from which I'm not allowed to deviate, that's just an APA argument. That's not, a Loper Bright argument.
Brenna, do you see CMS going more towards guidance documents because of these developments? How do you think that they're looking at this? I know you said they're probably spending a lot more bandwidth on Jarkesy. But under Loper Bright, do you think they're concerned about how things will go and are looking at guidance documents as a way to address it?
Yeah, I agree with Sean that I think it's less likely. I mean, in the last administration was very focused on guidance documents and using guidance documents inappropriately. And when I was at HHS, actually, I drafted a rule that would have in some ways it codified case law, but in other ways it made things a little more strict and held the agency to a higher standard. And it reiterated that you cannot issue a guidance document that imposes binding new obligations on regulated entities. And it really, I think, underscored that HHS faces limitations in terms of how much it can do things with guidance. So FDA, I think, is kind of the worst culprit in kind of putting out this guidance that they label as draft and not our final thinking, but everyone has kind of, compelled to follow it anyway. HHS definitely doesn't do that quite as much. But, in all events, there's still, there are ways to challenge guidance. And I think especially with a lot of the judges that were appointed in the last administration as well, judges that are more receptive to those types of arguments to agencies trying to slide things by regulated entities.
Sean, one of the things that you focused on was drug approval and talking about the possibility that those that are unhappy with FDA's decision might feel like they have more opportunities to challenge that now. How about competitors who have a competitive drug with similar applications that they're not happy that FDA approved their competitors' drug? Would they have standing, first of all, to challenge that, and would they have any more opportunities now than they didn't have before?
And mifepristone notwithstanding, the ability of a competitor to challenge a drug approval is pretty well established. Okay. There are, at this point, hundreds of exclusivity and Hatch-Waxman cases of all different flavors that support that notion. Just as when your approval is challenged, you have the right to intervene as a defendant. That's equally well established. So that form of litigation will continue. It's very important. Typically, when you have this sort of challenge, well, I mean, there are some sort of well-trod options for that. So, for instance, brands frequently argue that FDA was too lenient in whatever it required for bioequivalence for a generic. And you might imagine that spilling over into the biologics process as biosimilars and interchangeables continue to grow in scope. So I do think that those kinds of challenges may get a little bit of a shot in the arm from Loper Bright, just because that's a place where we'll just use a concrete example. There was a case in the 90s in the DC circuit where the question was whether FDA had exceeded its authority in construing the term same active ingredient, where they had established, I think it was a 4-factor test for a particular drug substance, and some of those substances, or some of those factors might require data that was sort of tacking towards safety and efficacy data, which you're not allowed to include in an ANDA under the terms of the statute. And the DC circuit basically upheld all of that under Chevron Step 2. And so, you could see, certainly in DC, that's still good precedent, but that doesn't tell us what's good precedent in Texas.
Right.
And, it's pretty specific to the particular drug substance in question and, various other problems. So, maybe that gets revisited in a court, particularly, some of the newer district judges who some of whom are very aggressive in terms of what they're willing to tackle subject matter wise. You could see them digging into something like that.
How about situations where FDA has to determine whether something's a drug or a device? There's been a good amount of litigation in that space. Do you see more challenges being brought if FDA takes a more aggressive tack towards identifying something as a drug rather than a device?
Yeah, so they lost that case, right? That
Right.
was the other Genus, or the Genus case that's cited in the deck. And that case, they actually lost Chevron step 1, right? And one of the points before Loper Bright came down, one of the reasons why some people were skeptical that the court would actually go that far was because Chevron step 1 had become so beefy, right? Like, we do everything from, looking at the structure and other provisions of the statute to applying the pro-veteran canon sometimes, right? Like, I mean, everything you could throw at the problem, you were supposed to throw at the problem. And Kaiser said that in the regulatory context. And so some were expecting we would just rely on a souped up version of Chevron step 1 rather than just undoing the whole thing. So, FDA, one, they're going to see something similar happen in ACLA and the AMP case, unless, something changes to, like, for instance, the Valid Act gets passed and that resets the board for LDTs. But there's also the drug exclusion clause and the dietary supplement definition, right, which is very similar to the drug exclusion clause and the device definition, at least in practice. So, I think there's lots of litigation like that in an appropriate case could be challenged. Now, one of the things FDA is really good at is avoiding the appropriate case, right? Like, they know what can be challenged in court pretty much just as well as we do. And if they can avoid doing that, they will.
Well, we've reached the end of our time here, and Brenna had to jump off, unfortunately, but thank you, Sean, for joining us today, and thank you to our participants joining us today. After we sign off, there'll be a quick survey that pops up on another screen in one of your browsers, and if you could take a moment to fill that out, we really appreciate it. Thanks very much for joining us today.